PreHearing Conference and the resource guidelines, protective custody hearing. Everybody's got these, right? And also the adoption permanency guidelines. No, you need to get that. They're on the website with the National Council, and you can also get a hard copy. Could I ask, is there anybody who's read this? I mean, not just the bullet cards in the back that break down all the aspects of the hearings. Have you read the chapters in the last 30 days? 45. 60. The whole thing now. Read the whole thing. 90? 12 months. Read the whole thing? This is the first conference ever. Here's a brand new silver dollar there for you, the gold type. How about that? It's the James Monroe one, you know. See? You should have read it. I suggest you do. I've given out hundreds and hundreds and hundreds of these since it came out, and I'm sure that they're collecting dust all over everywhere. This is good stuff. I challenged a colleague of mine who's on a separate juvenile court bench one day. He said, you know, you're always talking about these resource guidelines. You're driving me crazy. I said, thank you. Because when I became a judge and started hearing cases in January of '94, and I had practiced in our juvenile court as a private and then as a county attorney, I always wondered about these aberrational behaviors that were going on. Ex parte communication, hearings that didn't start on time, finish on time, were not meaningful, did not engage parents, didn't seem to get anybody anywhere, and I thought, this makes a lot of sense. So I did some research. This is pre-internet, and I found out about the National Council of Juvenile and Family Court Judges. So I went, and I never stopped going back. Professionally and personally, this group has been lifeblood for me. And this judge, I promised the judge, you know, dinner, drinks, the whole bit, just read this thing. Came back and said, wow, that's good stuff. It makes perfect sense. So, we're going to look at that a little bit. Do you remember this quote? You know who did that?
Kennedy.
Yeah, Bobby Kennedy, right? He's a pretty smart guy. And I wonder if that's what we're all thinking here as we see practice as it exists and the desire to do better, you know, with whatever we can bring to the table. So that resource guideline, by the way, when was this published? 1995. Not only took Nebraska till 2006 to think it'd be a good idea if we all started doing it, but that's okay. Hendry had a vision, he went to the summit. That's what kicked this thing off, and we had our summit, and out it goes. When was the council established? 1937, 71 years ago. It is the oldest judicial organization in America. The adoption permanency planning is 2000, focusing strictly on these issues. Similar concept. I'm suggesting to the council it's time to do one document, put everything together that we've got in that regard in ASFA, et cetera. The first one is a lot of what ASFA came from exactly, and we worked with congressional staffers on all those matters. And it's not a perfect law, everybody knows. So, problem-solving courts. Again, the judge sets the tone for civility, respect, demeanor, dignity. Encourages others to do the same. I mean, that's part of the current canons, bless you, with the American Bar Association Code of Judicial Conduct, and in the new one, we're debating what we're going to do with the 07 one, but it's still in there. Affirmation with accountability motivates parental change. And resolution of permanency. ADR works, family group conferences, mediation, for any issue from the very beginning. We're doing expedited family group conferences, but I think the pre-hearing conferences are pulling things together nicely, and it's changing the lie of the land a little bit. The pre-hearing conference, I believe, I experience, and I know many of you are experiencing, this makes that protective custody hearing work well. It started in Arizona at the Pima County Model Court over 12 years ago. They were champions of alternative dispute resolution, and they thought this would be a smart way to slow the process down. We worked with them, and we started that 4 years ago this July. Ours is a little different, as I'm sure yours may be. Pima County has an hour and a half per family, an hour and a half. And they also have the facilities where you can go and do it in conference rooms at court. We didn't. We have no space. We have no time. So my job was to try to convince colleagues, What if we had a meaningful first hearing with a pre-hearing conference? Would you consider letting the courtroom be used? What am I going to be doing? I said, something else. You know, that thing called administrative time we don't have. So, not all of my colleagues think it works as well as most of my colleagues think it works. That's okay. You know, people have different opinions of this, and people view the role of the judge differently too. I'm hoping, though, it will become a state rule. So this will be the way all courts do it, whether we want to or not. This is what unloaded Pima County's child welfare system. It was so good that it became law, statute. Take the resource guidelines, build on it. Thorough, meaningful, moves litigation forward quickly, sets the tone for a problem-solving atmosphere. It's a form of ADR, obviously. The facilitator helps lead to agreements on parental identification, Indian Child Welfare Act, placement issues, parenting time, services, applies good judgment, analytical skills. The facilitator models civility, respect, demeanor. Must know the court, must know procedure, rules, must be well aware of child abuse, neglect issues, time management, time constraints, has to be skilled with high conflict resolution and yet remain neutral, be an effective communicator, dealing with a high pressure situation where parents come in trauma, concentration in a tense environment as they're listening well. Are any of you trained mediators? Any judges trained mediators? I decided to do this 98, and I went to the basic mediation. I was the only judge. Half of us were lawyers, half were therapists, clinicians of some type. First thing the judges and lawyers found out is we do not listen well. Because we do the law school method. Issue spotting, checklist, got that done. Versus the listening, getting past almost the onion peel idea that you got to get to the core of what it's really about. I'd encourage everybody to do it. It's phenomenal. These people work miracles, I think. Preparation includes, and there's variations on this, but our mediators, as you know, are neutral. Neutral. And so some thought we shouldn't be reading this information, we should go in blind. Well, you can know and yet remain neutral because you don't want to get fooled. You can't do reality testing if you don't have a good solid basis of what we're really talking about. The forms are on the website. We've got those forms, we've got the original ones from Pima and some variations. Ours put the courtroom tables together. We have an agenda put on the wall so that the parents can see, here's what we're going to be talking about. Gets it set up. Now, some lawyers thought about it like this. How about if we settle this with a coin flip? How to tell you're not at the top of your lawyer's priority list. You know, Judge, I don't even know what this is. I don't want to do it. Fine, sit down. You're going to learn. The agenda. I have chosen to introduce this, and here's why. In our community, and I've heard from some of you a similar thing, CPS workers change, county attorneys change, guardians ad litem change, defense attorneys change, CASAs can change, and this is the first time these parents are in court oftentimes. This is new to them. So if I've got not only the parents, but I've got new players who may or may not have come to trainings that we have to continue to provide ongoing, they won't know what it's about and they don't know if it's important. So I walk out on my robe, I say, good morning. My name's Doug Johnson, I'm the judge here in courtroom 1. I want to tell you a little bit about what we're going to do. Your family is so important that we have set aside an hour to slow things down. This is a traumatic situation. I might say, I've seen the petition, I signed on the removal order, but I want to tell you what we're going to do at this time. We have a facilitator, and I might say it's Miss Katie King from the Concord Center, who's a trained mediator and facilitator who's totally neutral. Here's our agenda with a number of very important topics to your family. This is a chance to talk off the record and without admission against interest. Now, every family has strengths. This is a civil action, not a criminal one. If these charges are true, I don't punish you or put you in jail. but would work with you to improve these issues so you can meet your child's best interest. That's what this is all about. So if anybody likes some coffee or water, we've got it available. After you've had a chance to work through the pre-hearing conference, let my bailiff know. I'll come in for the formal part. And I leave. The facilitators tells me it makes a huge difference because it sets the tone. It lets everybody know this is important. The judge said so. So I'm still doing it. I've had people say, oh, Judge, this is special. They need to talk to you in chambers. Every time I hear that, I think, what isn't special about court? It's all special. You want to talk to me off the record ex parte to influence my thinking without the parents. Why? Unless it's a pretrial, what do you want to talk to me about? I don't have time for 2 hearings. Judge, this cannot be facilitated. This involves the death of a baby. This guy's up for felony murder charges. The other 2 toddlers have been put in foster care. This cannot be facilitated. Please go and sit down. Health and Human Services has a duty to provide reasonable efforts. Now, I didn't say relinquishment, but I got a young parent, I've got domestic violence issues, and we've got a dead baby. They need to know there are some options out there. What ultimately happened was both parents relinquished their rights. We closed that case, at least with regard to them, in 45 days. The kids were freed up for permanency. I've never seen one yet that's not doable, but it depends if we believe it's doable. So, setting the tone is critical. Stating the goals is very important. It's got to be simple, concrete, specific. And what the ground rules are: respect, civility. If persons start to get too heated, we're going to take a break. Let's slow down. Let's slow down. But you will be heard. The facilitator would have everybody say who they are, because the parents don't know who they are. This is CPS. Oh yeah, the child snatcher. This is the prosecutor. Yeah, and you signed off for him. They need to know who the players are. Discuss procedural questions, if there are any. Problem solving, it's off the record. I always say, you'll notice my court reporter's not here. This is a private conversation. CPS has the duty to offer services if reasonable, and if you decide to participate in them, no admission against interest. It's confidential. 5 issues is what we're doing. PEMA says theirs is 3. We fleshed it out a little differently, and I think they weave these in anyway too. Identify. Did I put impregnator? Yeah. I thought I put father. You know, every time I go for that F, it goes right to I. Indian Child Welfare Act, let's get notice to the tribe. Placement of the children, can they safely return home? Oh, did the defense hate that? The guardians ad litem, the prosecutor? Judge, why do you have them ask that question? That is so emotional. Don't you know we've just taken it? I said, did you read the resource guidelines? First thing, should the child be returned home immediately or kept in foster care prior to trial? That's the question we're supposed to ask. Can this child safely go home? How? Then, if you can't go home, they're going to start getting why your kid's in foster care. Oh, there's a problem. These are the issues we're going to have to be working on. There is no sense in hiding the ball here. What about relative placement? That's a good relative placement with a healthy relationship and not something that's going to detract from our primary goal. Parenting time, visitation, quality. Quality. These are things that, depending on the players, go very deep or very superficial. And what I'm encouraging our facilitators to do is let it go. Do what you would really do. So when they go superficial on something, oh, supervise 2 times a week, 2 hours. You ask them questions. Well, now, how old do you think this will affect the child? How old are the children? Oh, you have a baby. Has anybody considered bond and attachment? We've got to ask probative questions. Is there a way we can have relatives help with visitation so the baby's safe, so the children are safe? Aunt Sally, she jumps in and says, hey, I can provide placement. I go in and they're giving me the pre-hearing conference resolution, and so I ask a question. I say, Aunt Sally, I'm so glad you're willing to have Jimmy come live with you. By the way, where do you live? Oh, I live in La Vista. That's a little southwest from Omaha, in the corner by Sarpy. But mom lived in North Omaha. And little boy is a 4th grader. And it's March, April, May, whatever. I said, well, what about Johnny's school? How are we going to make sure that Johnny stays in the same school? Because if he loses his playmates and his teachers, we've just ripped out more attachments, right? Or, excuse me, you said you wanted to separate the siblings? Put them in different foster homes? Why would we do that? Why would we break yet another attachment? Right? How would you like your kids to be treated? Or your sister, your brother? Would we look at it differently? What are the services that could help this family? Pragmatic, accessible, and not just, we'll make a referral. When were you going to do that? Well, I'm not the ongoing caseworker. Who is? Haven't assigned it yet. When will that occur? Well, I don't know. I'll check with my supervisor. Okay, let's do that. And then you call the guardian ad litem. You call this afternoon so we know who that is. Or why don't you make the referral now for the substance eval? Why don't you go see the domestic violence advocate now? Who's going to walk mom over there to get her safety? Right? Triage. Roadblocks. Poor tone. In my area, maybe I shouldn't say it's a tone thing, but they know it won't happen in certain courts. Okay. Somebody attempts to reorder the agenda. We had some young prosecutors saying, I'm not agreeing that this isn't a admission against interest. And I'm saying, do you know what the rules of settlement conference are? It's confidential. You can't use it. Managing strained relationships. Grandma may be there. She's upset at daughter who went on another drug binge, went back to the abusing boyfriend. Who knows? They are emotional. Can we slow it down to try to deal with the issues? That case I told you about where the baby was thrown to the wall and killed, that petition contained a TPR, termination of parental rights, and that's one of the reasons they also said we cannot facilitate this. I said, no, yes we can, get in there. Unrealistic expectations. There's only so much time, but we can do quite a bit, I think. Maybe too large a number of family and friends. My court's pretty small. I wish I had a larger one. But if these people took the time to come, that says something. We don't want to get stuck. Good facilitators know how to deal with that and move on. Or you park it. This is too hot to handle right now. Let's get back to the narrow. What about when we know ICWA should apply, but the tribe's not represented? That happens to us quite a bit. And the pleadings when they came in are not ICWA related. Well, we know there's going to be amended pleadings then, and the tribe needs to be able to weigh in. Or we get a newbie, AKA, I missed that training, or I'd rather fight than switch, or why mediate when I can litigate? When I have the choice, I do not appoint these people. Ask how the children are doing. How are the parents doing? What do you need now? What's something special your child has at home that we could get to your child that will help? If mom has to be separated from baby, make sure mom has a blanket, baby blanket, some other item of clothing that she keeps close to her person so it has mom's scent, and put that with the baby to hold on to know mom's smell when mom's not there. What can we and you, parent, do to make it better? How often is the child there at a protective custody hearing? I don't hardly ever see it. Crisis needs, age-appropriate counseling, grief therapy for children separated from parents, thrown in with strangers. Can you imagine if you or I right now, with law enforcement, picked us up and said, get your belongings, we're going. You say, where am I going? I'm at a conference. I know, but I'm going to take you for your own safety and well-being. And as you know, safety is the paramount concern. So I'm going to have to bring, well, where are we going? I don't know this neighborhood. Don't worry about that. Well, what's this house? That's where you're going to live. Well, who are these people? Don't worry, you'll meet them. What do you mean this is my bedroom? This isn't my bedroom. This is where you're going to sleep. This is what you'll eat. Well, when do I get to go home? I don't know. That's not my problem. You know, you just got to be patient. For how long? I really don't know. And you enter into the life of foster care. Wow. So, if we have to go out of home, hopefully it's with somebody that Johnny or Susie knows and has a relationship with. One of my friends in San Jose, Judge Catherine Lucero, has this, and I can't remember the name. Doc, maybe you know what this is. It's kind of like a genealogy thing, but instead of just genealogy, it's about important relationships to this child. I can't remember the name for that. And it could be a coach, it could be a music teacher, it could be a scout troop leader. Do you know what the name of that thing is? That's it. I would love to start getting those, and maybe if you've got them, somebody could pass them around, but it builds on relationships that are healthy for these kids. We're dealing with things in a short time frame. Naysayers tend not to want to do this, and they prefer to have an informal discussion, usually out in the hall without the parents, and overwhelming the parents with too many unintelligible case plan tasks. So KISS, remember that one? Keep it simple. I didn't say the S word. Other problems, time. Attorney hasn't met with client. Managing language issues. I have a hard time getting the right Sudanese interpreter. And it's not just Sudanese, there's bazillions of dialects, and I found that out the hard way. Getting incarcerated parents in and timely to participate.
What do you do with those, Judge?
Incarcerated parents?
Do you want to garnet light them, or what do you do?
I've got a wonderful bailiff, and she anticipates and she knows the person who schedules things at the sheriff's office. Harder is to get from Lincoln if they're in the pen, but she tries to stay on top of it. When they haven't come, I might continue it as to that person and go forward with mom if that's what I've got. But if I don't have service, I'm stuck, and then we bring it back the next Wednesday. And then they'll say, well, do we have to do a pre-hearing conference on that? I go, well, sure we do. Yeah, it's hard.
So you try to get them, you try to get them out of Lincoln to get them to there?
You bet. You bet.
And see, we're 400 miles away, so it's complicated.
That's huge. Yeah, and you know, but I think
Comes up pretty often.
it's a hard one. So the agreement should be recorded and written down on the form. That gets buy-in that lasts. It's an operative worksheet. You know, a friend of mine who's a judge told me a long time ago, the judge who rules least rules best. And that's because what is resolved volitionally, I didn't have to order. And there was the buy-in. I am participating. I am making a difference right now, first day. And see, these sorts of things can develop out of this kind of problem-solving atmosphere. See the two knights? The one says, time out, please, eyelash. See? Who would have thought? See, civility. Chivalry. So the closing is, what are the loose ends we've got here? Where do we go next? Get the parties to sign the case plan. I have trouble with that still. Sometimes defense will still say, don't sign that thing. We're not committing to anything. We just talked about stuff. Well, culture change. When we had PIMA up a couple springs ago to do a whole day training again on this stuff, and people kept coming up, but. Finally, my friend Chris Swenson, the facilitator there, said, you know, all I can tell you is some of you are where we were 10 years ago. It's a culture shift. That's what it is. And they don't teach it in law school very much. They're starting to teach ADR, but it's still a new thing. Thank you, tell the bailiff it's completed. Now, in doing this teamwork, you got to watch it, judges and others, because Bob began to wonder if he says, take one for the team a little too often. So as we're working on these problem-solving things, it is a process, and not everybody is as far in the process as others. And so that's a personal journey, but with repeated training and seeing some success, that can get some buy-in. Resource guidelines. Now let's go right into the first hearing. I believe this is the most important hearing we do. Day one. This sets the foundation for everything else. And if we get it right, we won't have to go back over problems in the future. That's how important this pre-hearing conference is leading into this hearing, which is an evidentiary hearing. What are our key decisions? You're going to be applying some of these decisions shortly to fact patterns. Judges need to make an informed decision. Can this child go home or not? And why? You got to tell the you got to show the judge why. No professional hallway conferences. Get the parents involved. Early identification of the parental strengths, relatives, timely services. What services would allow the child to remain at home safely, and is there a safety plan? Will the parents voluntarily participate in services? No admission against interest. I put that in my orders too. I'll say as a result of the pre-hearing conference, the parties have agreed, boom. Dad's identified or is not, we're going to have referral for child support paternity testing. We talked a little bit about that, still a problem for us. The Indian Child Welfare Act, notice will be given to these tribes by such and such a date by the department, et cetera. And then I put at the end of it, if it's substance eval, whatever, mental health eval, participation in services in the pre-hearing conference do not constitute admission against interest. I put it right in the order. Then if somebody wants to appeal it, that's fine. I hope I'm giving my friends on the Court of Appeals and above a hint that if anybody doubted it, these were the rules and I put in my order also. Judge?
You said participating in voluntary services. If there's been no admissions yet, who ends up paying for those services?
Health and Human Services if the parent can't afford them. ASFA requires reasonable efforts to be offered to prevent the removal. And as you know, in Nebraska, removal is done by law enforcement. They have no services other than their gun, their badge, their mace, and their car. And they pull them out and bring them to crisis centers or some form of shelter care, right? Then the department gets involved. Then they have to do the initial assessment and figure out what can we do to help this family. Now, sometimes they go together, and that's ideal, because then you got child welfare plus law enforcement. But if the department just received this child and they don't know what's going on, how can you offer something? And I've had that. Judge, we don't know anything about this family. I said, well, let's read this. Let's see. Domestic violence, use of marijuana impairs ability to parent, lack of adequate housing. What do you think we ought to do? Didn't we already know 70% of our cases are mental health, substance abuse, and all the co-occurring issues? I mean, either you're neglecting them, you're beating them, you're off high, you don't have housing, right? I'm not saying it's all one type, but we ought to be able to read that petition and the affidavit that accompanied it and say, here's some preliminary ideas. And then those evals should be set up quickly. And I will tell the parent, by the way, if the eval says you need substance treatment of one kind or another, you can do that too without admission against interest. It's like the tort cases, remember? Clean up the oil off the floor so we don't have one more slip and fall. Can they use that to prove up the tort case? They want a safe harbor so future people don't get hurt. It's kind of a similar civil remedy, I think. So, and then when the department talks about we want to get kids home sooner, why would we wait 90 days for an adjudication only to order evals for a disposition, 30 days, 60 days from there? And then if the eval didn't happen, why? I don't know why. Continue another 30, 60. We've just blown 6, 7, 8 months of a 12-month permanency planning time with a kid in foster care and supervised visitation? Wow. Is the placement least disruptive in the most family-like setting for the child? Who will send the notice? Who's going to monitor to make sure the services happen? It's one thing to make the referral. Did it in fact happen? Who's going to follow up? That's where I think everybody needs to be more hands-on to follow through. Do we need restraining orders? What kinds of services evals? Terms of parenting time? Child support referral? Anybody missing? Get notice to them. Findings then that the judges will make were reasonable efforts offered to, number one, prevent the removal. And I might say in my first removal order, which I get, no reasonable efforts were offered. This was a law enforcement removal. But now that CPS is involved, they will do an initial assessment for services. I better know something when we have this hearing. And if not, I want to know why they don't know what they're offering. Number two, to reunify. What services will be offered to reunify then if we had to remove? There's nothing we could do at this point. Even if we do a substance eval, even if we did treatment, because of the nature of this case, we have to see that there's therapeutic progress before the child can go home, right? So then we're doing it, we reunify. So it's specific and tied to the evidence. Then the contrary to the welfare, safety, and best interest, specific tied to the evidence, a finding that the judge can make. Here's why this child can't go home. Very plain, very straightforward, so the parent gets it. I cannot return your home to you when you were on methamphetamine. You were unable to attend to your child's needs. Your life is out of control. This child cannot safely be with you. That's what the issue is. So, evidentiary findings. Just because the department, the prosecutor, the GAL, the defense lawyer recommends a particular finding and order doesn't mean it's going to happen. The judge has an independent duty to consider the evidence and make a judicial decision, and that drives some people crazy. Judge, I thought you said we were in a problem-solving role. Yeah, but I still am a judge. I got to make findings. So, you remember that McCarville thing? I'm sorry. It's the evidence. Remember when Bill Clinton was having a hard time with his second term and McCarville went to the war room and said, it's the economy. Well, it's the evidence that people got to remember the judges rule on. And we don't work in a vacuum. Our decisions and their quality about children and their parents are directly related to what the lawyers give us, whether it's prosecution, guardian ad litem, or defense. And if it doesn't come in, how are we going to know? So that hallway discussion you had, or we want to talk to you in chambers, doesn't translate to evidence. Okay? So, how about if we be the change we want to see and model it? Oh, did I show you that slide? You know, you can join the National Council of Juvenile Family Court Judges even if you're not a judge. That's a great deal. 71st year, did I tell you about that? Oldest judicial orders in